The truth about the research conducted by social psychologists. Social psychologists, defense attorneys, academicians, and law enforcement interrogation critics oftentimes refer to research that they claim supports their statements. However, they rarely disclose the details of that research. In this presentation, we will discuss three of the most common claims made by this group about law enforcement interrogation techniques and reference the research that they use to support these claims. First, some background on the issue of false confessions. There exists no controlled study investigating the validity or reliability of field interrogation techniques and their impact on the accuracy of confession statements. The only approach to conduct such a study would be to subject actual individuals who had essentially the same personalities and backgrounds to identical interrogation techniques. If half of the group was known to be without a doubt innocent of the crime and the other half was known to be guilty, a statistical analysis could be performed on the effectiveness of the interrogation techniques that were utilized on innocent and guilty suspects who confessed. Not only is this an immensely impractical methodology, but it clearly would violate ethical research standards established by the American Psychological Association. So consequently, statistics on interrogation practices must be collected indirectly. Existing research in the area of criminal interrogation can be divided into the following three categories. Anecdotal reports. This is usually a collection of data/cases selected because it supports a hypothesis. Anecdotal reports/cases are chosen precisely because they appear to support an underlying hypothesis that may or may not have any real statistical significance. Surveys, data collected on actual interrogations or confessions, either through observation, review of documents, or self-reporting. And laboratory studies. Oftentimes, a simulated situation is created to study the frequency or incidence of a particular phenomena, false memories, suggestibility, etc. If survey data is collected in a random and representative manner, it offers the greatest possible insight on factors that are important to consider within real-life confessions. One such study is reported by Richard Leo, who surveyed 182 interrogations conducted by 3 different metropolitan police departments. Among the cases analyzed, not a single false confession was reported within the random sample. Here is a reference to his article on the study inside the interrogation room. Another example of survey data involved 112 investigators from the states of Alaska and Minnesota who had all received training in the Reid technique of interviewing and interrogation. These investigators reported obtaining a total of 3,162 confessions during the previous 2 years. Of these confessions in which the Reid technique was presumably used in whole or in part, only 18.56% were suppressed at trial, and the majority were suppressed due to Miranda violations. When the focus of research is on actual police interrogation practices, as opposed to anecdotal accounts of possibly false confessions or laboratory recreations of police interrogations, survey results indicate that the vast majority of confessions obtained through interrogation are non-coercive and held to be admissible as evidence. Now, that's not to suggest that the issue of possible false confessions should be ignored, but rather that it be kept in perspective. Laboratory studies will be discussed a little later in this presentation. So as I mentioned earlier, there are 3 claims we're going to look at that social psychologists typically make. The first claim is that misrepresenting evidence to a subject during an interrogation will cause innocent people to confess. Social psychologists often claim that police lie to suspects about evidence such as telling the suspect that there was a witness who saw them at the scene of the crime, that their DNA was found on the victim, that their fingerprints were found on the murder weapon, etc. They suggest that innocent people will confess when told about this evidence. And they support this claim by referencing anecdotal cases in which an innocent person did confess after they were advised of false evidence. However, they typically fail to mention that in each of these cases that they reference, the investigators engaged in threats, promises of leniency, denial of rights, excessively long interrogations, or other coercive behaviors. So it isn't the misrepresentation of evidence that caused the confession, but the investigators' use of coercive and abusive tactics. For more details regarding this issue of misrepresenting evidence to the suspect, see our YouTube presentation entitled False Confession Experts. They only tell you part of the story. And a second presentation on our YouTube channel, Is it permissible to lie to a suspect about evidence? In addition to anecdotal cases, social psychologists will reference research that they suggest demonstrates that lying to a suspect about false evidence will cause innocent people to confess. One of the studies they use is referred to as the Alt Key study. In the Alt Key study, students were required to perform a data entry project and were cautioned not to hit the computer's Alt key because if they did, the computer would crash. However, unbeknownst to the students, as they were entering the data, the researchers forced the system to crash, and then they falsely accused the students of hitting the Alt key. They also confronted them with a witness who reported seeing them do so. Under these circumstances, a number of students signed written confessions despite their innocence. Here's the article that details the elements of this research: the social psychology of false confessions, compliance, internalization, and confabulation. A second study that social psychologists oftentimes reference to support their claim that misrepresenting evidence in and of itself will cause innocent people to confess is one in which students were given a set of assignments and told that in some of the assignments they could collaborate with other classmates, but in others they could not. The researchers then accused innocent students of improperly collaborating on certain assignments, informed them that they had violated university rules prohibiting cheating, and for some tried to minimize the extent of their wrongdoing and encourage them to take responsibility for their actions. Half of the students were told that there was a hidden camera in the room which would eventually reveal their guilt or innocence. This is the lie about evidence. There really was no camera, that the researchers wanted to see how much that would influence the statements made by respectively truthful and deceptive persons. Under this circumstance, 93% of the guilty suspects confessed, and 50% of the innocent suspects confessed. However, when you look behind the curtain at the details of the study, as it turned out, these innocent participants did not confess to helping out the other persons at all. Rather, they signed a prepared statement stating that they helped the other person, but had been reassured that if the hidden camera exonerated them, which all of the innocent fully expected to happen, they would not get into any trouble by signing the statement. In other words, the innocent participants were manipulated into believing that signing the confession would not result in any negative consequences. If this technique was used in an actual criminal case, encouraging suspects to sign a written confession by offering them a promise that if future evidence exonerated them, the confession wouldn't be used against them, it would clearly shock the conscience of the court and the community and undoubtedly be suppressed. The article that discusses this research about lying to the students about the camera, etc., is called Inside Interrogation: The Lie, the Bluff, and False Confessions. In U.S. versus Jocks, when discussing these studies, the court stated that obviously these interrogations were not conducted by law enforcement, were not part of a criminal investigation, did not involve actual suspects, and did not present the students with any serious penalty. As a result, Professor Hirsch, the false confession expert in this case who introduced these studies, readily admitted that these studies have limited value, which in the context of this case is an understatement. It should be noted that one of the authors of the above referenced study, Casson, made the statement that one needs to be cautious in generalizing from laboratory experiments. They know the weakness of this research. Claim number 2. Investigators oftentimes misclassify subjects as to their truthfulness or deception, so as a result, they oftentimes interrogate innocent individuals. The basis for this claim is research conducted by social psychologists that suggests an investigator's ability to determine a subject's credibility based on their verbal and nonverbal behaviors in terms of accuracy is no better than chance. However, again, when you look behind the curtain at the details of the research, you'll see that it has very little applicability to real-life investigations. Most of the detection of deception research studies that are referenced involve studies that were conducted in the laboratory using students to commit mock crimes. For example, having students steal money from an office drawer and then assigning half of them to be innocent and half to be guilty when they were interviewed by an investigator about their possible involvement, who was trying to discern from their behavior if they were truthful or not truthful. Other studies involved having convicted criminals on video describing the crime that they committed, and then in a second video describing a crime they did not commit, but describing it as though they did. The viewer is then shown both videos and asked to determine which is the truthful statement and which is the false statement. There are a number of reasons why laboratory studies generally are not applicable to real-life situations. First of all, the subjects, whether they be students or prisoners, have very low levels of motivation to be believed or to avoid detection. There's no consequence one way or the other. The interviews of the subjects were not conducted by investigators trained in interviewing criminal subjects. The studies did not employ the type of structured interview process that is commonly utilized by investigators in the field. In most studies, there was no attempt to establish a behavioral baseline for each subject so as to identify changes from their normal behavioral pattern, which is crucial, and I'll expand on that shortly. And the research was based on the faulty premise that there are specific behavior symptoms that are unique to truth or deception. Let me be perfectly clear, there are no behaviors unique to deception. Take, for example, eye contact. We expect a person to look us in the eye when they answer the question. Oftentimes, if they don't, we may view that with suspicion, maybe an indication of deception. But there are other reasons a person may not look at us in the eye. Could be cultural considerations, psychological considerations, a particular distraction at that moment, all kinds of things that we have to allow for. All behavior has to be viewed in context, and a number of variables must be considered, such as the subject's age, culture, mental capacity, emotional and psychological stability, and their physical condition, possibly the influence of drugs, alcohol, or medical problems. Take the response, I don't know. If I asked each of you what you did 7 weeks ago on Thursday evening, everyone in this room would say, I don't know. Completely understandable. Now, if you look at a calendar, you might go, oh my gosh, I know exactly where I was. I was in the emergency room with my youngster. He broke his arm playing basketball. But absent something out of the extreme like that, none of us would have any recall on what we did 7 weeks ago, so I don't know is a very acceptable answer. However, if in a homicide investigation I ask you, as one of the neighbors to the victim, did you have anything to do with causing your neighbor's death last night, and you say, I don't know, we have a whole different ballgame. So context is everything in terms of behavior. In most research studies, the interview is evaluated in a vacuum. In the real world, the investigative interview of a subject takes place in the context of an investigation. For example, by the time the investigators interview a subject, they may already have developed information about the subject's relationship with the victim, their whereabouts at the time of the crime, their financial situation, and other relevant background material. They may have already developed evidence that implicates the suspect, eyewitnesses, DNA, trace evidence, etc. In the research studies, the suspects are interviewed in a vacuum with the investigator conducting the interview without any background information about the subject or how they might fit into the investigation. In the research studies, the investigator is asked to make a decision as to the subject's credibility, their truthfulness, based solely on the behavior he or she exhibited during the interview. In the real world, the investigator makes a judgment about the suspect's possible involvement in committing the crime based on their behavior and the case facts and evidence, including information from other subjects. When researchers attempt to design studies that more closely approximate the setting of real-life interviews, they show a marked increase in the ability of investigators to detect deception. Consider the following. A study conducted by researchers from the Korea University, Michigan State University, and Texas State University San Marcos found that using active questioning of individuals as utilized in the field in real-life cases yielded an accuracy rate of 97.8% in detecting deception. Here's the article that describes that research in detail. In the Reid technique, we teach that there are several rules that must be followed in the evaluation of a subject's behavior symptom. Rule number 1 is critical, and in the research, they rarely ever do this. It's critical to establish a subject's normal behavioral pattern and then look for changes from that norm. Everybody's different. Everybody has their own mannerisms, the way they speak, their tone of voice, how they use illustrators, etc. So we always begin our investigative interviews talking about biographical information, what they do for a living, casual conversation, maybe about a recent news event, weather issue in the area, etc., to kind of get a baseline for the subject, how they sit, how they respond, what kind of eye contact they maintain, etc. So that later on, when we get into the arson that's under investigation and we see a significant change from that norm, the change is what becomes significant. Without a norm or baseline, we've got nothing to base anything on. It's important that we read all nonverbal behavior for timing and consistency. Everybody in an investigative interview that lasts 30 minutes, 45 minutes, an hour is going to move, shift their weight, etc. Movement by itself doesn't mean anything. It's the timing of it. Is it in conjunction with an answer, or is it in between responses, etc.? It's important that the investigator reads behavioral cluster, the overall behavioral pattern, not just single isolated observations. And finally, we always evaluate behavior in conjunction with our case facts and evidence. If these rules are followed, investigators can be very accurate in assessing a subject's credibility. Claim number 3. Social psychologists suggest that offering the suspect a moral or psychological justification for committing the crime is the same as offering them a promise of leniency. Social psychologists describe the interrogation process as one in which the interrogator tries to minimize or downplay the seriousness or consequences of the alleged act to make it easier for the suspect to confess. As Richard Leo has said, quote, by minimizing the consequences or the outcome or the punishment, minimization communicates a suggestion or promise of either leniency or reduced punishment in exchange for cooperation. An essential part of the Reid technique is during the interrogation process to suggest face-saving excuses for the subject's crime, which may include projecting the blame away from the subject onto such elements as financial pressures, the victim's behavior, an accomplice, their emotions at the time, presence of alcohol clouding their judgment, etc. There are 2 types of acceptable minimization that occur during an interrogation: minimizing the moral seriousness of the behavior and minimizing the psychological consequences of the behavior. We never teach to minimize the legal consequences of the subject's behavior. So social psychologists claim that offering the suspect the excuse, for example, that he committed the crime due to the suggestion of an accomplice, is essentially the same as telling him that if he confesses that he committed the crime because of the accomplice talking him into it, he will face less punishment. The research that they typically use to support this claim is a study conducted by Casson and McNall, in which the effects of different interrogation techniques on levels of perceived guilt or responsibility were investigated. Specifically, in this study, college students read 5 different interrogation transcripts of a murder suspect. In the first one, the investigator made an explicit promise of leniency. In the second, the suspect was threatened with a harsh sentence. In the third, the victim was blamed. In the fourth, the suspect was falsely told that his fingerprints were found on the murder weapon, and the fifth transcript did not contain any of these variables. After reading each transcript, the students rendered opinion as to how long they thought the suspect would be sentenced. And the researchers found it significant that the students believed the sentence would be less severe in the condition in which the victim was blamed for the homicide. So the authors of this study take that and argue that the perceived leniency attributed to such a theme could cause a false confession through what they call pragmatic implication. Even though the investigator did not promise leniency, there's an implicit implication that the subject would face less punishment if his accomplice talked him into committing the crime. However, they do point out, quote, because our findings are based on inferences drawn by college students, relatively uninvolved but highly educated observers, it remains to be seen whether similar inferences are drawn by real crime suspects. The courts reject the principle of pragmatic implication. As an example, the Supreme Court of Canada made the statement, the most important decision in all cases is to look for a quid pro quo by the investigators, regardless of whether it comes in the form of a threat or a promise. If you confess, you won't go to jail. If you don't confess, you'll never see your family again. That's a quid pro quo. Clearly, those are problematic. In summary, the studies that many social psychologists use to support their claims about law enforcement interrogation techniques are based on research that is seriously flawed, is generally not applicable to real-life situations, and as the authors have stated, one needs to be cautious in generalizing from laboratory experiments. With respects to how the courts view the issue, in United States versus Begay, the court found that there is no scientifically reliable means of determining whether a confession is false. The court stated that, crucially, there does not appear to be a reliable estimate of how many confessions are false confessions, regardless of the interrogation tactic employed. They also stated that false confession theory cannot reliably determine whether a given confession is false. And they also stated that a further limitation on false confession science is that false confession theory does not appear to be based on any significant empirical data, but instead appears to be based primarily on anecdotal evidence, small sample size studies, or extrapolations from inapposite situations. So while social psychologists testify that all of the research indicates A, B, or C, the research is very limited. For additional information on this topic, see our book, Criminal Interrogation and Confessions. You'll find details about the book on our website, Reid.com. Thank you very much for taking a few minutes to listen to this presentation.